She stood at my truck window, knuckles rapping on the glass like she was trying to wake the dead, pointing at the bright yellow tow warning sticker she just slapped on my windshield. Didn't ask if the truck was mine, didn't verify the parking violation, didn't even pretend to care that I'd been parked legally in a guest spot for exactly 47 minutes. Just walked up with her laminated HOA president badge dangling from a lanyard and decided my truck was her business. This woman had sent me 12 violation notices in 8 months for things that weren't violations. She'd called code enforcement on my fence, my mailbox, and once memorably on the color of my garden hose. And now she was threatening to tow my truck from a guest parking space I had every legal right to use. What she didn't know was that I'd been documenting every single interaction, every bogus notice, every overreach of her imaginary authority. And what she really didn't know was that her own driveway, the one she was so proud of with the decorative pavers and the little solar lights, was about to become the most educational parking spot of her entire HOA career. What would you do if your HOA president threatened to tow your legally parked vehicle? Drop it in the comments. And where are you watching from? Let me know below. Let me take you back to where this started. My name is Colin Drexler, 42 years old, systems engineer for a telecommunications company. I spend my days troubleshooting network infrastructure and my nights trying to enjoy the townhouse I bought 3 years ago in a planned community called Meadowbrook Estates, just outside Columbus, Ohio. 2-story brick townhouse, small front yard, attached garage, and a guest parking area approximately 80 feet from my front door. The community has 186 units, all owner-occupied or rented, managed by a volunteer HOA board that meets once a month in the community center near the retention pond. I bought my unit in 2021, signed the HOA documents at closing, paid my quarterly dues on time, and generally tried to stay out of everyone's way. That worked fine for about 18 months. Then Diane Kettleman got elected HOA president. Diane is a 54-year-old former office manager who retired early after her husband sold his plumbing supply business. She has the kind of schedule that allows her to monitor the neighborhood full-time, which she does, driving her white Lexus SUV slowly through the streets at various hours, photographing cars, trash cans, and anything else she's decided requires documentation. She wears a polo shirt with the Meadowbrook Estates logo embroidered on it, even though nobody asked her to and the HOA doesn't issue uniforms. She carries a clipboard in her passenger seat. She has been HOA president for 14 months, and in that time, violation notices have increased by 340%. I know this because another resident, a data analyst named Greg, tracked it and posted the numbers in the community Facebook group before Diane had him removed as a moderator. The first notice I received was about my trash cans. I'd left them at the curb 4 hours past the HOA-mandated retrieval time, which, according to the covenants, was 8:00 p.m. on collection day. I'd gotten home at 9:30 p.m. because of a work emergency. The notice was dated 8:17 p.m., meaning Diane had been driving around checking trash cans within 17 minutes of the deadline. I brought the cans in, ignored the notice, and assumed that was the end of it. It was not the end of it. 2 weeks later, I got a notice about my front door wreath. Apparently, seasonal decorations were only permitted during the 30 days preceding the holiday they represented. My autumn wreath, hung in mid-September, was cited as premature. The notice included a photograph taken from the street with a zoom lens. I took the wreath down. I was annoyed, but I took it down. Then came the fence notice, the mailbox notice, the garden hose notice, and eventually on a Tuesday morning in late April, the truck notice. I'd parked my truck, a 2019 Ford F-150, in guest parking space G7 at approximately 6:30 p.m. because my garage was full of storage boxes I was reorganizing. Guest parking at Meadowbrook is clearly defined in the covenants. Any resident may use guest spaces for up to 72 consecutive hours. Overnight parking is permitted. No permit or advance notice is required. I'd parked there before without issue. But on this particular evening, Diane decided my truck was a problem. At 7:17 p.m., she placed a bright yellow tow warning sticker on my windshield. The sticker said the vehicle was in violation of HOA parking policy and would be towed within 24 hours if not moved. At 7:43 p.m., she knocked on my door, clipboard in hand, and informed me that my truck was, quote, taking up valuable guest parking that actual guests might need. I asked her which guest was currently being inconvenienced. She said that wasn't the point. The point was that I had a garage and should use it. I told her the covenants allowed residents to park in guest spaces. She said the covenants were subject to interpretation by the board. I said the covenants were actually subject to the plain language written in them, which I'd read. She said she'd have my truck towed if it wasn't moved by morning. Then she walked back to her Lexus and drove away. I stood in my doorway for a moment. Then I went inside, opened my laptop, and did what I always do when something doesn't sit right. I started reading. Here's your first practical insight, and I want you to actually remember this one. Your HOA covenants are a legal contract, not a suggestion list. Every rule, every restriction, every enforcement mechanism is written down and recorded with the county. If someone tells you a rule exists, find it in writing. If they can't show you the specific section, the rule doesn't exist the way they're claiming it does. Takeaway: always request the specific covenant section number for any alleged violation. If the HOA can't cite it, the violation notice has no legal standing. I opened the Meadowbrook Estates Covenants, the full recorded document, 47 pages, filed with the Franklin County Recorder in 2006. I searched for every reference to parking. Section 8.3 covered guest parking. The language was unambiguous. Guest spaces were available to residents and their guests on a first-come, first-served basis for up to 72 hours per vehicle. No restriction on resident use. No requirement to prioritize actual guests over resident vehicles. No authorization for the board to reinterpret the rule based on garage availability. Diane's tow threat had no basis in the covenants she was supposedly enforcing. I screenshotted the section, saved it, and then did something else. I filed a formal complaint with the HOA board requesting an emergency review of the tow warning under Section 12.4 of the covenants, which allowed any resident to challenge an enforcement action they believed was incorrect. The complaint went to all 5 board members via email, timestamped with the relevant covenant language attached. Then I walked outside, photographed my truck in Space G7, photographed the tow sticker, and noted the time. The sticker stayed on my windshield. The truck stayed in the space. Diane did not respond to my complaint. The board did not acknowledge receipt. But 3 days later I received a new notice, this time claiming my truck had been parked in the same guest space for more than 72 hours, which was factually untrue. I'd moved it twice during that period, once to run errands, once to refuel. I had timestamps, receipts, and GPS data from my phone proving the truck had left the property. I documented all of it, added it to a folder I'd started keeping, and sent a second email to the board. Still no response. That's when I called a lawyer. His name was Paul Reinhardt, 59 years old, solo practitioner in Columbus who specialized in property law and HOA disputes. I'd found him through a referral from Greg, the data analyst who'd been tracking Diane's violation notices. Paul had handled 2 other cases against Meadowbrook Estates in the past 4 years, both settled quietly, both involving Diane. We met at his office on a Thursday afternoon. I brought the folder. He read through everything, looked up at me and said, "She's done this before and she's going to keep doing it until someone makes it expensive." Paul explained that Ohio law governing HOAs is unusually favorable to homeowners compared to some other states. Under Ohio Revised Code Section 5311, an HOA must follow its own recorded covenants exactly as written. Any enforcement action that deviates from the plain language of the covenants can be challenged, and if the homeowner prevails, the HOA can be liable for the homeowner's legal fees. More importantly, Paul said, if an HOA board member acts outside their authority in a way that causes harm or harassment to a resident, that board member can be held personally liable, not just the HOA as an organization. That got my attention. Paul suggested we do 2 things immediately. First, send a formal cease and desist letter to Diane personally, not just the board, citing the specific covenant sections she'd violated and notifying her that further baseless enforcement actions would be considered harassment. Second, file a records request under Ohio's nonprofit corporation law to obtain all board meeting minutes, email correspondence, and enforcement logs from the past 18 months. The goal was to document whether Diane's actions against me were part of a broader pattern of unauthorized enforcement. The cease and desist went out certified mail on a Monday. The records request went to the HOA's registered agent the same day. I paid Paul a $1,500 retainer. It was worth every dollar. Diane received the cease and desist on a Wednesday. I know this because the tracking receipt confirmed delivery at 11:04 a.m. At 3:47 p.m. that same day she called me. I didn't answer. She left a voicemail. Ohio is a one-party consent state for recording phone calls, meaning I can legally record any conversation I'm part of without notifying the other person. I'd already set my phone to automatically record all calls from unknown numbers and known problem contacts. Diane's number was flagged. The voicemail was 90 seconds long. In it, she said my lawyer's letter was, quote, a bullying tactic, that I was, quote, trying to intimidate the board, and that if I, quote, continued down this path, she would make sure every single rule in the covenants was enforced against me to the letter. She also said she'd be watching my property closely. I saved the voicemail. I sent it to Paul. He called me back in 15 minutes and said, "That's retaliation, document everything." Here's your second practical insight. When someone in authority threatens retaliation after you assert your legal rights, record it, save it, and tell your attorney immediately. Retaliation is not just unethical, it's often illegal, and it dramatically strengthens your position in any subsequent legal action. Takeaway: in one-party consent states, recording threatening or retaliatory communication can provide critical evidence that shifts the entire dynamic of an HOA dispute. The records request came back 3 weeks later in a banker's box that smelled like a basement. I opened it at my kitchen table with Paul on speakerphone. Inside were printed emails, meeting minutes, and enforcement logs going back 18 months. By page 20, Paul was laughing, not the cruel kind, the kind that means you've just found exactly what you were looking for. Diane had issued 217 violation notices during her 14-month tenure as president. Of those, 68 had been formally challenged by residents. Of those 68, 61 had been overturned or quietly withdrawn after residents provided documentation proving the violations were inaccurate. Diane had a 90% failure rate on contested enforcement actions, but she kept issuing notices anyway. More importantly, the board meeting minutes showed that Diane had been issuing violation notices without board approval. According to Meadowbrook's bylaws, any enforcement action had to be authorized by a majority vote of the board recorded in the minutes. Diane had been skipping that step entirely, issuing notices on her own authority using HOA letterhead and her president title to make them appear official. Paul said, "This isn't an HOA enforcement issue anymore. This is one person using an organization's authority for personal purposes. That's actionable." We filed a formal complaint with the Ohio Secretary of State's office, which oversees nonprofit corporations, alleging that Diane was operating outside the scope of her authority as defined in the HOA's bylaws. We also filed a separate complaint with the Franklin County Prosecutor's Office flagging potential misuse of organizational resources. Neither complaint resulted in immediate action, but both created official records, files sitting in government offices waiting. Then Diane made her next move. She hired a towing company. The company was called Rapid Response Towing, based in a strip mall on the east side of Columbus. Diane added them as an, quote, authorized enforcement partner for Meadowbrook Estates, which sounds official until you realize that the HOA bylaws contain no provision allowing the president to unilaterally hire contractors without board approval. She placed rapid response towing signs in the guest parking area, bright yellow with red lettering, warning that unauthorized vehicles would be towed at owner's expense. My truck was still parked in space G7. I'd been moving it every 48 hours, documenting every movement, keeping meticulous logs. Diane knew this. She'd been photographing my truck every time I moved it. I have pictures of her taking pictures. On a Saturday morning in early June, I came outside to find my truck hooked up to a rapid response flatbed, driver in the cab about 30 seconds from pulling away. I walked up, showed him my registration, showed him my HOA covenant printout highlighting section 8.3 and told him the tow was unauthorized. He looked at the paperwork, looked at me, looked at his dispatch sheet and said, "Lady who called this in said it was abandoned." I said, "Does it look abandoned?" He unhooked my truck, handed me a business card and said, "You might want to talk to a lawyer." I already had one. Paul filed a civil complaint the following Monday. The defendant wasn't the HOA, it was Diane Kettleman personally. The complaint alleged harassment, abuse of authority, attempted theft of property through fraudulent towing, and violation of Ohio's Consumer Sales Practices Act, which prohibits deceptive business practices. We weren't suing for damages yet. We were suing for an injunction, a court order prohibiting Diane from issuing any further enforcement actions against me without prior board approval, documented in writing. The complaint was served to Diane at her home on a Wednesday afternoon. She wasn't expecting it. I know this because Greg, the data analyst, lived 3 doors down from her and watched the process server hand her the papers. He texted me a single word, boom. The hearing was scheduled for 4 weeks out. In the meantime, Paul advised me to do something that seemed counterintuitive. He told me to keep parking in guest space G7, keep documenting, keep moving the truck every 48 hours and wait for Diane to do something stupid. She did. What Diane did next wasn't just stupid, it was the kind of stupid that makes lawyers smile and judges frown. She went to the Meadowbrook Estates Facebook group, the private community page with 140 members, and posted a long, detailed statement about me. She didn't use my name. She didn't have to. She described, quote, a resident who is abusing guest parking, harassing the board with frivolous legal threats, and attempting to intimidate HOA leadership. She included a photograph of my truck in space G7. She invited other residents to report any further, quote, suspicious behavior from my property. The post stayed up for 6 hours before the remaining moderators took it down. But screenshots live forever, and I had 3 of them sent to me by other residents who were by this point quietly rooting for me. Paul added the screenshots to the case file. Defamation, he said, clear, public, and stupid. The hearing took place in Franklin County Common Pleas Court on a Tuesday morning in July. Diane showed up with an attorney, a younger guy in a suit that looked rented, carrying a briefcase that looked new. Paul showed up with an accordion folder that looked like it had been through a war. The judge was a woman named Carolyn Voss, late 50s, no nonsense, the kind of judge who reads the filings before the hearing and doesn't tolerate nonsense. She opened by asking Diane's attorney whether his client had board authorization to issue the violation notices in question. He said the board had given Diane general authority to enforce the covenants. Judge Voss said, I didn't ask about general authority, I asked about specific authorization, show me the meeting minutes. He couldn't, Paul could. Paul had the minutes showing that Diane had issued 217 notices without a single recorded board vote authorizing enforcement actions. Judge Voss read for about 90 seconds, looked up and said, Ms. Kettleman, did you authorize a towing company to remove Mr. Drexler's vehicle from a guest parking space he was legally entitled to use? Diane said the truck was taking up space that guests needed. Judge Voss said, "That's not what I asked." The hearing lasted 22 minutes. Judge Voss issued a preliminary injunction prohibiting Diane from issuing any enforcement action against me or my property without prior written board approval, documented in meeting minutes and provided to me in advance. She also ordered Diane to pay my legal fees incurred up to that point, which totaled $4,200. Diane's attorney looked like he wanted to be anywhere else. Diane looked like she'd swallowed a lemon. Paul looked like a man who'd done this before. Walked out of the courthouse into the July heat. Paul said, "Now comes the fun part." The fun part, as Paul described it, was letting Diane's own behavior finish the job. The injunction was served to Diane and the HOA board on a Thursday. By Saturday, Diane had resigned as HOA president, not because the board forced her out, but because her homeowner's insurance attorney advised her that continued involvement in HOA leadership while under a court injunction would void her liability coverage. She submitted a one-paragraph resignation letter. The board accepted it the same day. But Diane still lived in Meadowbrook Estates, 3 streets over from me, and she still drove her white Lexus through the neighborhood, and she still had opinions about how things should be run. She just didn't have authority anymore. That's when I started researching her property, not out of spite, out of curiosity. If someone spends 14 months obsessively enforcing rules against other people, it's worth checking whether they're following those same rules themselves. I pulled Diane's property records from the Franklin County Auditor's website, public information, free to access, searchable by address. Her townhouse had the same basic layout as mine, but the records showed she'd pulled a building permit 3 years ago for a, quote, driveway expansion and decorative hardscape installation. I pulled the permit documents. The approved plan showed a driveway expansion adding 8 feet of width to her existing driveway, bringing the total width to 18 feet. But when I drove past her house, and I did slowly legally from the public street, her driveway looked wider than 18 feet. I measured it using a surveying app on my phone, 24 feet, 6 feet wider than the permitted plan. Under Meadowbrook's covenants, any exterior modification requires HOA approval and must match the approved permit exactly. Diane's driveway didn't match. I filed a violation notice against Diane with the HOA board, not because I cared about her driveway, but because the rules she'd weaponized against everyone else should apply to her too. The board sent an inspector. The inspector confirmed the driveway exceeded the permitted dimensions. The board issued a formal violation notice requiring Diane to submit a revised plan or restore the driveway to permitted specs within 60 days. Diane did neither. Instead, she filed a complaint with the board claiming the measurement was inaccurate. The board hired a licensed surveyor. The surveyor confirmed 24 feet. Diane was fined $500 and given 30 days to comply. That's when she called me again. I didn't answer. She left another voicemail, this one shorter, angrier, accusing me of harassment and, quote, using the HOA as a weapon. I saved the voicemail. I sent it to Paul. He said, "The irony is so thick you could pave a driveway with it." But here's where it gets interesting, and this is the part I want you to pay attention to, because this is where the legal structure I'd been building quietly in the background started to do the work I'd designed it to do. Diane's driveway wasn't just oversized. It extended beyond her property line by approximately 14 inches onto the HOA's common area greenbelt. I know this because I requested a copy of the original surveyor's report the HOA had commissioned, which included a site map. That 14-inch encroachment meant Diane had been parking on HOA common property without authorization for 3 years. Under Ohio law, unauthorized use of common area property by an individual homeowner is classified as conversion of common assets, and it exposes the homeowner to liability for the fair rental value of the space used. Paul calculated the fair rental value of 14 inches of driveway space over 3 years at approximately $1,800. Not a huge number, but a number with legal weight. The HOA board, now operating without Diane's influence, voted to require her to either remove the encroaching portion of her driveway or pay the HOA for the unauthorized use. Diane chose neither. She hired an attorney and threatened to sue the HOA for selective enforcement. The board's attorney responded with a letter outlining Diane's 14-month history of unauthorized enforcement actions, the court injunction, and the documented evidence of her own covenant violations. Diane's attorney withdrew from the case 2 weeks later. That's when I made my move, the one this whole story has been building toward. I contacted the HOA board and made a formal request under Section 9.7 of the covenants, which allowed any resident to lease unused common area space for private use with board approval. I requested permission to lease a portion of the greenbelt adjacent to Diane's property, specifically the 14-inch strip her driveway was already occupying, for the purpose of, quote, temporary vehicle parking during property maintenance activities. The board approved my request unanimously. The lease was $50 per month paid to the HOA's operating fund. I paid 6 months up front. Then I parked my truck on that 14-inch strip of common area greenbelt that Diane's driveway had been illegally occupying for 3 years. Legally, properly, with written board authorization and a signed lease agreement. My truck was now parked technically in Diane's driveway, or rather in the space her driveway had stolen from the HOA which I was now leasing. She came outside 4 minutes after I parked. I was standing next to my truck, lease agreement in hand, waiting. She said, "You can't park here." I said, "I have a signed lease from the HOA for this specific space. Would you like to see it?" She said, "This is my driveway." I said, "Actually, according to the survey the HOA commissioned, this 14-inch strip is HOA common property that your driveway has been encroaching on without authorization. I'm leasing it, legally." She stared at me. I handed her a copy of the lease. She read it. Her face went through several colors. Then she went inside and slammed the door. My truck stayed parked there for 6 days, legally, quietly, with written authorization. On the 7th day, Diane submitted a formal application to the HOA to remove the encroaching portion of her driveway and restore it to the permitted dimensions. The board approved the application. She hired a contractor. The work was completed in 3 days. My lease terminated automatically once the encroachment was removed as specified in the lease terms. I moved my truck back to guest space G7. Diane never filed another violation notice against anyone. The HOA board implemented new bylaws requiring all enforcement actions to be approved by majority vote and documented in meeting minutes before any notice could be issued. Greg, the data analyst, was elected HOA president 4 months later. Violation notices dropped by 80% in his first year. I still live in Meadowbrook Estates. I still park in guest space G7 occasionally. Diane still lives 3 streets over, but she doesn't drive through the neighborhood with a clipboard anymore. She doesn't wear the polo shirt. She doesn't attend board meetings. The Lexus stays in her driveway, the correctly sized, fully permitted, non-encroaching driveway. I see her sometimes at the grocery store. We don't speak. We don't need to. Paul Reinhardt sent me a bottle of bourbon when it was all over. The card said, "For the most technically correct use of a greenbelt lease I've ever seen." I opened it on my back patio, poured a glass, and watched the sun go down over Meadowbrook Estates. Quiet, peaceful, exactly the way I'd imagined it when I bought the place. The whole thing taught me something I didn't fully understand before. Authority without accountability is just bullying with paperwork. And the best way to stop a bully isn't to out-yell them. It's to out-document them, out-research them, and outwait them until they make the mistake you've been quietly preparing for. Diane made that mistake when she threatened to tow my truck. She made it again when she posted about me on Facebook. She made it a 3rd time when she built a driveway that didn't match her permit. Every mistake was documented, filed, and used exactly as the law allows. I didn't break any rules. I just read them more carefully than she did. And when the moment came, I parked my truck exactly where the rules said I could, in a space she'd been stealing for years, and I waited for her to realize what patience actually looks like. If you've ever dealt with an HOA president who thought the rules didn't apply to them, drop your story in the comments. And if you've ever wanted to know how to fight back legally, precisely, and with documentation that actually holds up, subscribe, because the quiet ones always have the best ending.